In 3, 2, 1. We continue the special joint meeting of the High Qualification Commission of Judges and the Public Council of International Experts, and please invite the candidate for the position of the judge of the High Anti-Corruption Court, Mr. Viktor Vasyliovych Maslov.
Добрий день, сідайте, будь ласка.
Hello. Please take your seat.
Надається питання щодо відповідності
Now
кандидата.
we are considering the issue of compliance of the candidate for the position of the judge of the Hague, Maslov Viktor Vasyliovych, with the criteria envisaged by Part 4, Article 8 of the Law of Ukraine on the High Anti-Corruption Court. And we here have the PCI members, Robert Heinberg Heisen, the chair of the PCI, Norman As, Mary Kay Butler remotely, Gabriele Yotkanaite, Granskiene remotely, John J. Sullivan, and also members of the High Qualification Commission of Judges, Mikhailo Poganis, Lyudmila Volkova, Vitaly Gatsiluk will join us in a minute, Yaroslav Dukh, Roman Kedysyuk, Oleg Kolyush, Igor Kushnir, Ruslan Melnik, Alexey Emelian, Sergei Chubak, and Galina Shevchuk. Do you understand the composition of the commission? Yes. And I'm explaining to you your rights. You have a right to submit motion for recusal based on requirements of the law, provide motions and provide explanations based on the agreement of the presiding chair, provide explanations and challenge the decisions of the commission. I pay your attention during this special joint meeting. We do not consider any documents submitted by the candidate. Now, if there was an opportunity for the candidate to submit documents before, but the candidate or other persons failed to do it, and upon the initiative of at least 3 PCI members or the Commission members, or with the majority of voting of the Commission and the PCI, the decision could be made on attaching of additional materials if at least 3 PCI members vote in favor of such decision. Do you understand your rights? Yes. Do you have any motions on recusal or any other motions? No. I also pay attention for all the rules that shall be complied by all participants of the meeting according to the rules of procedure of the Commission, according to information present in front of you. I'm the rapporteur on your case, and I will start. I will start my report. So, with the High Qualification Commission of Judges of Ukraine, and there was an announced competition for the High Anti-Corruption Court and the Appellate Chamber of the Hague. And Maslov Viktor Vasyliovych has submitted its application on participation in the competition and be subjected to the qualification assessment in order to comply with their capacity for participation in this competition. With the decision of the Commission as of 19 September 2025, Maslov was allowed to participate in the qualification assessment. As of decision of the Commission of 19 September 2025, the qualification exam was scheduled for competition and for the Hague and its appellate chamber. And with the decision of 19 September 2025, the qualification assessment was scheduled and the stages were defined. With the decision of the High Qualification Commission of Judges on 4th February 2024, first results were adopted, and upon the results of the qualification exam, the candidate got 352.03 points and was admitted to the second stage of interviews. Qualification of the candidate. In 2007, Mr. Maslov graduated from the Ukrainian Academy of Banking of the National Bank of Ukraine and received a full higher education in specialty jurisprudence and obtained the qualification of a lawyer. In 2012, Maslov graduated from the Yaroslav Mudry National Law University and received a full higher education in the specialty jurisprudence and obtained the qualification of a lawyer. The candidate has no academic title or scientific degree. Professional activities of the candidate. From 21st June 2007 to 2nd November 2007, Mr. Maslov worked as a court clerk in the Economic Commercial Court of the Sumy region. From 5th November 2007 to 16th September 2011, held the position of Chief Specialist of of the sector for representing the state interests in courts of the main Department of Justice in the Sumy region. From 16 September 2011 to 14 May 2012, he held the position of head of the analytical work, documentation and control department of the main Department of Justice in the Sumy region. By decree of the President of Ukraine as of 24th April 2012, Mr. Maslov was appointed judge of the Trostenets District Court of Sumy region. And by decree of the President of Ukraine as of April 11th, 2019, Mr. Maslov was appointed judge of the High Anti-Corruption Court. The candidate submitted integrity declarations, family ties declarations, as well as declaration of person authorized to perform the functions of the state or local self-government authorities. During the competition, the Commission sent requests to the State Judicial Administration, Ukraine relevant public authorities and institutions, and their replies were received. That's all from my side. Mr. Maslov, is it right? Everything? Did I make any mistakes? No, everything is right. And I give a floor to the chair of the PCA, Mr. Robert, over to you.
Thank you, Mr. Chair. Good afternoon, Mr. Maslov. My name is Robert Broekhuizen, and I'm also the rapporteur in your case, in your file. And so it's up to me to ask you some questions. Okay? The first question I would like to ask you is whether you have seen the publications of the EU regarding the accession of Ukraine to the EU and the requests the EU has for the change of the judiciary. Did you look at that yesterday? Did you see that?
Generally, I follow the news related to legal field, to the general station in the state. Yeah, of course, there are certain requirements regarding entering into the European Union, and I follow the news. I try to know the details of the developments.
Yes, one of the requests of the European Union is that there will be again a commission, like there was before, a selection commission for the High Qualification Commission of Judges. So that if new people are, let's say, selected for the High Qualification of Judges, that there is a commission that also consists of international experts. What's your view on that?
As that's my second time when I participate in the competition for the High Anti-Corruption Court, it means that I treat such commissions with respect and with all the respect to the work that you do. And after the first competition, there were the words of appraisal from the side of the public and from international partners regarding engagement of international experts in such commissions. Later, such experience was scaled up and started to be applied to other procedures and other competitions. Generally speaking, I think that engagement of such international experts into such competition procedures is fully relevant and worth because it increases trust to such competitions, to such procedures, and shows more independent approach to evaluation of candidates.
I have seen that at a certain moment you were in a position that you were delegated, if I'm not wrong, by the Council of Justice to be in a commission to elect judges for elect people for the High Qualification Commission. And that you did this that you were in this position at a certain moment in 2019. Is that correct?
I will correct a little bit this information. I was a member of the Council of Judges of Ukraine. It's a body of judicial self-governance authority, and it was engaged into delegation of candidates to the Competition Commission for the selection of the HQTJ members. I provided reply regarding it.
Okay, yes, I saw that. Sorry about that. And I understand that at a certain moment, civil society organizations accused you that you were involved in blocking the election of the selection commission that should select the High Qualification Commission. What is your answer to that? Is this something that is true, what the civil society organization said, or is that incorrect?
Ну, щодо цього питання вже мій колега з Ради суддів давав пояснення, Дмитро Мовчан.
I have provided explanation to this question. Movchan took part in my interview, so I can repeat my arguments. The Council of Justice judges actually considered this issue in time, and the High Council of Justice announced the competition for the selection to this commission. And right after the decision of the High Council of Justice to announce the competition, according to the law, we met a week after the decision of the High Council of Justice. We met and voted abiding by the law. So the arguments that the civil society organization quoted are not really appropriate.
Okay, thank you for that. And the reason I repeat this, of course, that this is an open competition where also the public can see that we ask you the questions. And let's say the fact that you have answered our questions in writing does not mean that we are not going to discuss those questions again. I'm sorry about that. There also have been some public statements, I'm told, about corruption in the Hague. Have you ever exercised corruption inside of the Hague, the High Anti-Corruption Court?
Я так розумію, це про ВАКС іде мова, да? Про суд.
So it's about the Hague Court, right?
Є абревіатура, яка затверджена наказом ВАКС. Ну, добре, відповідаючи на ваше запитання, безпосередніх
To respond to your question,
корупційних таких пропозицій до мене з роботи не надходить.
I haven't encountered corruption within Hague, and within the court I haven't heard of such cases, but there are criminal proceedings that I have considered when there were attempts to bribe some officials, and the latter agreed to provide for a positive outcome for them, but those cases are revealed. One case is in court, the other is in pre-trial.
You're talking about officials of the High Anti-Corruption Court? Or what kind of officials?
Дивіться, ну, умовно кажучи, є підозрюваний чи обвинувачений.
There is a suspect that wanted to get a positive outcome in a certain case, in a case where I was involved. This individual, this suspect, would turn to other Hague officials, and he promised them some amount of reward in order for them to make sure the case plays out in the suspect's favor. And this is why they were offered a reward. But when the suspect did not get a satisfactory outcome,
звернулася до правоохоронців, до НАБУ,
uh,
і повідомила про такий факт,
the
і
uh,
він знайшов своє викриття.
the suspect turned to
Зараз, як я зазначив, от,
NABU, and
цим останнім.
this is how cases were revealed. One case is in court,
брали ці кошти для
revealing the hack officials involved in those, and the other case is in pretrial.
Is this the case where you're talking about where there is, let's say, allegations in the news that were brought forward by the deputy head of the main department of the state tax service in Kiev? Is that the case you're mentioning, you're referring to?
Так саме про цього.
Yes, exactly.
Because this guy alleges that you were asking for money. That you saw that, huh?
Так.
Yes, correct.
And so I understand that was he the defendant in the case? This guy from the tax authority?
Так, стороною.
Okay.
Так, він був.
So this has been investigated.
Yes.
And it has been. Okay.
Він був обвинуваченим.
Yeah.
He was accused.
Він був обвинуваченим.
He was accused.
Хотів отримати бажане для себе рішення в тій справі.
He was the defendant in the case that I considered. So he turned to some individuals that would guarantee I make the ruling that he wanted to. Therefore, he reported about the situation to NABU, and this is how the case was revealed.
Yes. I was referred to another case where there was the head of the building management of the Yavoriv housing and operational unit of the armed forces of Ukraine, who I'm told made a deal with the prosecutor and pleaded guilty on certain allegations. And he made a deal with the prosecutor. That's what it was. And I understand that there was quite some comments about, also on Facebook, etc., the fact that you decided to acquit this person who was accused by prosecution to have committed the crime, corruption, falsification. And I also, when I think about it, I found it special, of course, you're a judge, you have to decide on all the merits of the case, that a person who has made Sorry?
The connection is unstable, therefore I'm listening and trying to make sense.
Well, it's always difficult with my questions, Mr. Chair.
Будь ласка.
You follow my question, Mr. Maslov?
Я думаю, що No.
Yes. So I was talking about this person, the head of the building management of the Yavoriv housing and operational unit of the armed forces, who pleaded guilty and made a deal with prosecution. And in the end, in this case, you decided, or the court where you were part of decided, that even though he pleaded guilty and he was willing to provide or give off a statement, you decided that not all the circumstances that should be fulfilled by criminal law were fulfilled, and that you set him free because you decided there was no criminal liability of this person, if I'm not mistaken. And there were some comments about that in the public domain, and I do understand that if there is someone who is willing to make a deal with prosecution, is willing to give off a statement, and willing to accept punishment, it's difficult to understand why such person is then set free. Can you shortly explain this to me? I'm sure you know which case I'm referring to.
Ну, можливо, трошки з перекладом не
So
зрозуміло.
probably I may have missed some parts of your question. So the gist of the case was the following. When we started working, it was one of the first cases that I received for consideration, and it arrived after the prosecutor set forth a charge against the suspect. And that case was also considered by a different collegium of judges. I wasn't part of that group of judges. When I saw that deal, and the collegium refuted the deal, qualification of the suspect's activities was inferior to the actual nature of his actions, and the wrong article was referred to, and other liable parties were not brought were not held accountable. And therefore, they hinted that the qualification should be changed, should be different. Then pre-trial body changed this qualification to a graver qualification. And after that, I received the case. I had to consider it, then interrogate all the parties and consider the proof, and then make a decision. So I was the chairman of the group of judges, a group of 3 judges that considered this case. So after examining the case files, the deals that had been made, about the rent of boiler room, we didn't found the charge to be comprehensive. And then, so in that charge, this judge said that there is no basis for the accused to be for the suspect to be accused. So we prepared a different charge. And this is about it, about this case.
Of course, I will not discuss to you why you took this decision, because it's within your, I would say, secrecy, I would expect. But I can imagine that the public would say this is very strange, because we have an individual who is willing to admit he committed a crime. He's willing to give off a statement. He's willing to undergo a punishment, and then he walks free. And so that means that the person that you were dealing with apparently understood that something was wrong in what he did.
Так, можливо, вона це розуміла, можливо,
Yeah, probably they understood that, or they were afraid of the gravity of punishment, because they were running a risk at having to get in prison, and this is why probably they pleaded guilty. And then the cost of the works was also an issue, and the prosecutor in their charge, she didn't incriminate the cost of works to the suspect, and the court could not assess this fact. The suspect may have understood that there are issues about the cost of works, the rent of equipment, and therefore that was an internal sort of, let's call it, mens rea of the suspect, and I cannot give you reasons for their conduct further.
Thank you, Mr. Maslov. I'm now turned to the next one I would like to discuss with you. That's a case where judgment was given, if I'm not mistaken, the 5th of April 2024, where you, with colleagues, sentenced a former deputy, Alexander Unishenko, to 15 years imprisonment. You remember that case?
Можливо, ще раз перекладіть прізвище обвинуваченого.
Could you repeat the surname, please, of the accused?
Onishenko.
Онищенко?
Yes.
Так, цю справу я знаю.
Yes.
Yeah, I know of this case.
And it was pronounced in absentia because
In absentie зробили.
Так, цю справу я знаю.
Yeah, I know of this case.
yeah, and the 20th of May 2025, the appeals chamber overturned this judgment. You know that, huh? And this is, it took me a bit of time before I understood it, but I have the judgment in front of me in translation. And that's the court of, I guess, the Court of Appeal judgment. And the judgment says, and I will read it to you, that Article 21 of the CPC of Ukraine provides that everyone is guaranteed the right to a fair hearing. Yes? And then this is specified and in many articles, I understand, and there's Article 367 of the CPC of Ukraine, and that says that during the adoption of a verdict, of a judgment, no one has the right to be in the deliberation room except for the composition of the court that conducts the trial. The court has the right to interrupt the meeting only for rest. With the onset of nighttime, during the break, judges cannot communicate with persons who participate in criminal proceedings. Judges do not have the right to disclose the course of discussion and sentencing in the deliberation room. Nighttime is considered to be from 10 p.m. to 6 a.m. And if I read this article, what it says is that if you're deliberating in a criminal case with your colleagues, the deliberation is in closed chambers and goes on until nighttime. And if you're not finished yet, you will continue the next day. And apparently, I guess, but I'm not sure, maybe you can explain that to me, these rules, they are there to avoid that during consideration about a criminal case, the judges are influenced by the outside world before they have come to terms and to their conclusion. And what I understand is that according to this article, a judge also of the Hague has to stay in the deliberation room with his colleagues, and it's only finished to get out if there is a judgment in place. Is that correct, what I say?
Ну, в принципі, мова
Well,
йде
basically,
про
we're talking about the secret of the chamber for deliberation. It is included in the Criminal Procedural Code of Ukraine, and that was violation on the part of Court of Appeals, where the secret of chamber for deliberations was not respected. So I was in the chamber for deliberation, and the collegium was receiving training at the school for judges. And that was one of the most complex cases that we ever had. More than 500 volumes. We have had many court sessions, and we spent multiple months in the chamber of deliberation. Of course, we had some needs of organizational, logistical needs, and the mandatory training previewed by the law also had to be done at that time. So I'll try to speak appropriately about these circumstances because I cannot really doubt of the Court of Appeals decision. Whatever conclusions they made them. But within the time that we were in the chamber of deliberation, we did not allow any communication with other participants, any other parties of that criminal proceeding. And on our part, we respected the secret of the chamber for deliberations, and we did not discuss the content of the case with anyone else. And another thing that I will emphasize, the Supreme Court has pronounced more than once on this issue on the importance of respecting the secret of the chamber for deliberations. The Supreme Court has a non-linear approach to this issue. They're saying that there must be some obvious signs of disclosure of that secret, and the Supreme Court does not believe it to be a violation when the judge deals with a different case while being in the chamber for deliberations for another case. This is why I joined the judges in the School of Judges, and they believe that that was not a violation of the secret. No circumstances of the case were not known to anyone else before the disclosure of the case, but the appellate court evaluated this in the way they did, and I cannot comment further.
I don't understand exactly what you are saying, because you say that the Supreme Court has apparently decided that deliberation in another criminal case, yes, may disturb deliberations in a case, but in this case it was not deliberation in another criminal case. You apparently went away to give a lecture to judges in another location outside the deliberation room. Am I right? So when I listen to you, I do not immediately understand that the Supreme Court.
Спробую ще раз. Я хочу зазначити про те, що
I would like to point out that the Supreme Court
дуже прискіпливо ставиться до цього.
is very thorough in terms of this matter. Not any involvement of a judge into any procedures is considered by it as a violation of the deliberations secrecy. The Supreme Court considered that a violation of the deliberation secrecy only when there are specific facts that display that some circumstances were discussed maybe with the parties to a party, or where some contact between the judges and the participants under the case. So not any involvement into any activity automatically results in the violation of the deliberation secrecy. In this particular case, I would like to repeat again that there were no facts, no circumstances that could show that we've disclosed the secrecy of deliberations among judges, that we took part in communication with the parties to the case. No, there were no facts during the appellate consideration, and they are not mentioned in the decision of the appellate chamber of the Hague.
Okay. Thank you for your answer. If what I read in the judgment, and I will read it to you, is that the Court of Appeal says that the court of the first instance, among which you violated the continuity of the trial and the secrecy of the deliberation room, since during their stay in the deliberation room, the judges systematically participated in various events not related to the adoption of a decision in this case. And to me, as a foreigner who doesn't know Ukrainian law, this looks quite serious, because a Court of Appeal of the Hague, and you want to be part of the Court of Appeal, if I'm not mistaken, they say to you, listen, friend, you violated essential obligations of a Hague judge in the first instance. And they don't say that for nothing. And and apparently you don't agree with this statement, do you? Or do you agree with it?
Ну, я зазначив свою думку.
I've provided my opinion. I would like to emphasize again. Here I'm bound to some extent by ethical rules and ethical commitments that do not allow me to assess conclusions of the appellate court in the judgment that has come into force. Obviously, when we were taking part in this event, we were aware of what we were doing, and we did not consider that as to be a violation of the secrecy of the deliberations room. And I'm still personally convinced that it was not a violation of the judge's deliberations secrecy, at least from the perspective of the case law of the Supreme Court. But in this case, there was adopted a decision to the contrary. And it would be, of course, good for this case to go through cassation review, but the panel of judges adopted the decision to return the case for new consideration. That's why the cassation court could not provide assessment of these circumstances.
Yes, you said, if I listened carefully to you, when we did this, we knew what we were doing, and we did not consider this to be a real risk. That's correct, huh? What I find difficult about this is that the result of the judgment of the appeal chamber of the High Anti-Corruption Court says that this case has to be done again. And we are talking about a guy that got 15 years of imprisonment, and where I understand that this is one of the most serious cases NABU ever did in the period 2013-2016. And of course, it is 10 years ago that those facts happened. And then this case finally is brought to court, to the court where you're in. And then you take a risk. And in the end, the result is that, it has to be done again. So the risk you took resulted in fact, something quite terrible. Don't you agree with me?
Well, I've pointed out that that is the ground that was decisive in this proceeding for the cancellation. You can see there that the appellate chamber reached also the conclusions that the court incorrectly assessed the report of economic expertise that determined damages under this case. So this circumstance that we are discussing was one of the grounds that served as a ground for the adoption of the decision by the appellate instance. At the same time, I would like to emphasize again that being in the deliberations room took several months. Objectively, we left the premises of the court. We went home. During the weekend, we talked to friends. We attended different events during our free from work time. And all of that was not considered as a violation of the secrecy of deliberations. But when we took part in the mandatory training set out by the law and in the meeting of judges, which is obviously an important event also envisioned by the law, then it was perceived as a violation of the deliberation secrecy. Personally, I believe that this violation did not take place.
Well, I can understand that when I read the judgment that you say this, to be frank, because of course it may be a formal, let's say, mistake or violation you've done, but for instance, in my country, if I would be in a deliberation room and there would be a case which was so big, it would be completely normal that other cases would come in between and you would do other activities. So in that respect, I can follow you. On the other hand, of course, I'm not practicing in Ukraine, I'm practicing in the Netherlands. So I know how it is with us and I know how it is in France and in Germany. And there it would be all very normal what you have done. So just to make clear to you that I understand what you say. I try not to attack you too hard in this respect, and therefore I say this to you. On the other hand, it's a violation in accordance with Ukrainian law, apparently.
Я зазначу про те, що
I would like to say that I will add my comment. This institute of the deliberations room is considered as a quite archaic institute, and there is a range of legislative amendments that are initiated in order to address this issue, so that judges are not bound by these harsh rules that they have to be in the same room, which is basically impossible during the period of a couple of months. So there is a draft law that will cancel this institute of the deliberations room in the current form.
Just to finalize this part of my questioning, is there anything you want to add to this, or is it?
І все, що хотів
No,
зазначити.
that's it. I've printed out everything that I wanted to print out.
Okay, very good. Now I'm going to discuss with you. You had a loan from your father in 2020. You recall that, huh? 780,000 hryvnias.
Так.
Approximately $29,000 at that time. Is correct?
Ні, не 1700, там була позика.
No, there was a loan and a gift.
Yes. The loan was first. The loan was first.
Так.
From 2020. And in 2021, the 2nd of October, you concluded a gift agreement with your father based on, and you received 1,530,550 hryvnias, approximately $56,000 in cash. Right?
Це було десь 50 на той
That
момент.
was about $50,000 back then in dollars.
And what I find special, but maybe you can explain that, it says in cash. Did you get it back with money from your father? Like this?
Це насправді не такі
No, in fact, it was not. That was not like such a large number of banknotes of money. I've described how it was happening, that a part of the funds, half of this amount, was repaid by me to him, and on the same date, he gifted the second half of this amount. Actually, it was done everything in order to properly declare all of this. It's obvious that we were not carrying bags with money and we were not exchanging bags. We came to the notary's office. These arrangements were executed in the manner specified by the law. And actually, through this legal transaction of the gifting, we recorded the movement of assets from the father to me, so that all of that is properly reflected in the declaration. But of course, maybe if ordinary persons who are not officials were doing the same actions, they would not even go to the notary. But since I have to report on the source of origin of my funds, I did all proper actions regarding proper execution of this legal transaction following the manner specified by the law through notarization of the deed of gift.
Just to understand that I understand correctly, you got a gift agreement with your father, $56,000, and you used half to repay the loan that you received from your father. That's correct, huh? That's what I understand that you did. No?
Ні, неправильно.
No, not correct. Look, I got a loan from my father in the amount of 780,000 hryvnias. I had to repay that to my father.
Після цього ми домовились про
After that, we agreed that he would gift this $50,000 to me in the dollar equivalent.
Оскільки я мав йому
Since I had to repay 780,000 to him, and he was supposed to give me this $50,000. So basically, instead of the full amount of 50,000, he gave me half of it, and the rest, like the other half that I was supposed to repay him to, I still had it in my hands, basically. So physically, we were not sharing money for the sake of the process. We just registered all of that through proper notarized manner.
And am I correct to think that in the agreement, or let's say the deed, it was said that you're going to use this money to buy a land plot? The 50,000?
В самій угоді, здається,
In
такого
the deed of gift, as far as I remember, we did not mention that, but maybe we mentioned that. But yes, that was the intent that I had, to buy a land plot.
Yeah, I think that this is the position, because then, in my mind, the deed would not be completely correct, because then it would contain, it should say, there's a gift to repay my loan and to buy a land plot. And that didn't say. And the 29,000 that you got it in cash in the bank? No?
Ще які кошти?
Which money?
Well, the half of the 56,000, half repayment of the loan, half you received. Was it paid in cash in the form of banknotes?
Так, готівкою, банкнотами,
Yes,
звичайно.
in cash and with banknotes, of course.
Я поясню, можливо.
I will explain maybe, just for you to understand why it happened like that. Because the ad on the land plot, I found it before we concluded this deed of gift for the money. So I understood the approximate amount that I had to pay for this land plot and which I needed to buy it. And since the ad clearly stipulated the price in dollars, in the amount of $50,000, so I understood that maybe I would need this particular amount of funds in cash in order to pay for this land plot. When we came to the notary's office, previously I had never bought the land plot, especially agricultural land plots. When we came to the notary's office, the notary explained that these transactions are conducted in non-cash form only. After that, I took these cash funds that I got from my father and I deposited them to my bank account. Then probably the first financial monitoring took place because the bank took a pause. They requested supporting documents to confirm the source of origin of these funds. I provided the bank with respective supporting documents, the deed of gift, information about income of my father, and accordingly the bank was checking all of this information. Then when this transaction was approved, these funds were at my bank account, and then they were transferred through the bank transfer to the account of the seller of the land plot. When the seller received this bank transfer, he withdrew them, he exchanged them into dollars, and that was the end of our agreement with him.
If I look at this, then with my eyes from Western Europe, I would say don't do this because it doesn't make it transparent, does it? But that will come over time. I have noted that you have a sister and a brother. That's correct, huh?
Є.
And
Yes.
did they also get $56,000 in cash?
Дивіться, у нас трошки
Look,
різні
We
відносини.
have slightly different relationships with the family with other kids.
Батька. По-перше,
I mean, my father. First of all, my sister is my half sister. We share the mother. She is not the daughter of my father.
Мої батьки були раніше.
My parents had been married before they got married, and accordingly, my sister was born in my mother's marriage, and my father had a son born in his previous marriage. So basically, my father has two kids, me and my brother. They never lived with my brother, actually, because my father got divorced and my brother lived in a separate family and is still independent, so to say. So basically, only I lived with my father, his son. And that's why actually all of those funds that he is getting, he mostly spent on me. And he's still taking part in terms of financial assistance. So my brother has a separate family. My sister is abroad, and she left after the start of the full-scale invasion, and she's still abroad.
Okay, thank you. The reason I ask you is that generally parents are very careful not to give one child more than another child. That's the reason I ask this. If I give money to my children, I will always be weighing how to do this. Then I would like to discuss with you something, many other things, but they cannot go on forever, which of course I would like to do. You acquired in 2023 a garden structure for 209,700 hryvnias. And I understand that you are allowed to build some a holiday house there, but you didn't do that yet. But you acquired a movable property. And I'm so wondering, what is a movable property? What is, and it's also described as I don't know how you pronounce this in Dutch, a gazebos, something like a tent or something that you put down there. And you declared this tent. You declared two tents, one tent that's open and a closed tent or a gazebos or something else. So can you explain to me, what did you declare? Gazebo. Huh? Gazebo. Gazebo? Yes, is that English? Yeah.
Ну, я, відповідаючи на запит Громадської ради міжнародних експертів, направив фото для того, щоб було
Answering
зрозуміло.
the questions of the PCA, I sent actually the photo to explain how it looked like. So how, and you saw in an agreement how it looked like, and the photos of the real image of it. So visually you can see what the structures are. So this is the gazebo. Yes, I don't know how to mention it in a different word. That's for temporal leisure designation, and I installed such two gazebos at my land plot for, for different weather conditions, to spend there our time with my family. They're located near the forest, and there's no house there because the full-scale invasion started, and our plans regarding construction of any permanent housing are postponed because of it till the end of the war.
But what you put down there is not a house. It's because I didn't see the photo.
Ні, це, ну, десь, мабуть, мають бути,
No,
тому що я
they shall be somewhere because I sent specifically photos to you.
Oh, well, I didn't see that. I'm sorry about that. I'm told that you in 2023 have not declared the ownership of your wife of a building and 2 land plots in Kruske. Sumi. Oh, here it is. Oh, yes. Oh, yeah, now I get it. Your gazebo. It looks nice, I must say. So can you please explain why you didn't declare that?
Я все
So
задекларував.
I declared everything in appropriate manner. Maybe it's not clear
В наступному році я
why it was done so, why I didn't declare it next year, but I declared everything for 1 year. So de facto, my wife inherited after her father's death the house and land plots. The same year, when she registered this property on her name after inheritance, she sold out this property to faraway relatives of her father. And in the corresponding declaration, she reflected this information. Give me a second. So she reflected it in the relevant declaration and indicated the sum of received income for alienation of this house and land plots, I think at the amount of 20,000 hryvnia. This house is in the rural area, and my wife didn't plan at all to register ownership right for this property because she was not interested in it. That property doesn't have any significant value. She inherited it only in order to register part of an apartment on her name, which was owned by her father. But that property and land plots were not planned to register on her name. But the relative reached out to her because she planned to take usage for that property. My wife issued a power of attorney to this relative, and this relative handled all paperwork regarding registration of that property because there were some missing documents. They needed to receive court decision regarding the house in order to get property right over it. And when the full package of documents was ready, the property right was registered on my wife's name. In the register all the information was filled in. And the same year, she actually sold this property to the same relative for symbolic value for this relative to keep using this property.
Yeah, it was sold to a grandmother, huh? Or a
Це
sister of,
якась дальня родичка, я, здається,
sister to the grandmother. But
я
when I read this,
намагаюся знайти, де я
I'm trying to find, so it was like a far relative, some kind of far family connections.
yeah, I was wondering, why do you sell property to a very old lady? Seems to be weird.
Ну, тому що вона
Because
підтримувала спілкування з
she maintained communication with my wife's father, who died. And actually, no one claimed that property. I don't know what was their thoughts when they tried to get that property and that house, those land plots. But actually, that property didn't have significant value. And as I mentioned, my wife didn't plan at all to register this property at her name. Only upon request of that relative, she took such registration steps to register it on her name. And my wife didn't communicate a lot with her father. I think I saw him only twice during all our life. So after the divorce, there were certain family relations, specific ones. And so my wife didn't plan to claim that property. She wanted, so only upon request of her relative, she took measures to correspondingly transfer that property to her name.
Okay, thank you. Now my last question, because I want to leave some time for the HQCJ and not to use more time than we agreed. What I've noted, don't take me wrong, is that you like speeding in the city, going too fast. And is it a good idea for a Hague judge to be speeding in the city?
Я намагаюсь
I'm trying
зменшити кількість принаймні цих
to
порушень.
decrease at least such number of such violations. I consider myself a disciplined driver. I'm experienced driver. So, and yeah, maybe once, twice, or 3 times per year, such violations from my side are documented. They are not of the nature which could lead to choosing dangerous speed when I would be incapable to respond to traffic and road situation. No, maybe such cases were related to lack of attention from my side to the speed rules, to the speed regime. I accept it. It means I always pay fines as envisaged by legislation. I try to take measures which would prevent me from violating more such rules. I use cruise control tool at the car, but yes, indeed, there were such violations. I can't anything to add. And yeah, of course, it would be better not to have them, but I do everything possible to prevent such violations, such cases.
Yeah, the reason I'm asking it is that I found your answer also in writing strange. You say, I'm a good driver. There are 11 cases of speeding, which up to 20 kilometers per hour. And that's not so dangerous. And at the same time, I didn't have much attention. I think the combination of not having attention and speeding beyond the limit in the area of a city is extremely dangerous. Don't you agree?
Перше, там не все в межах
So first of
міста
all,
відбувалось
not
порушення.
all those cases happened within city limits. Secondly, some cases, some violations took place early morning when there's always almost no traffic at all, no cars, and 3 lanes are empty. And I just can't create any danger either for myself or for other people around me. So not all cases indeed manifested the increased danger to other people. Of course, there were some violations within the city limits. Indeed, I admit it. I will try to avoid such violations in future.
Very good. Thank you for that. I could have asked 1,000 more questions, but just look at my colleagues. Mary, Gabrielle? No? Back to you, Mr. Chair.
Дякую. Регламент є
Thank
регламент.
you. Yeah, the rules of procedure are as it is. We have agreed upon certain timing, so yeah, thank you for sticking to it. Mr. Robert, actually you have asked
Більшу кількість питань, які
major part of questions that
як у громадських організацій.
the CSOs and HQCJ had to the candidate. And we have received information from the CSOs such as Transparency International and CPK, and some of those questions were not covered by the PCA, and I'm going to ask them right now. First of all, it's related to purchase and selling of the property of specifically of the residential house and 2 land plots, as it was mentioned already by Mr. Robert, and the value for alienation of the property 20,000 hryvnia. So 8,000 for a land plot, 8,900 for another land plot, and the rest for the residential house. Is it right? Yes, it's right. Everything is reflected in the agreement, but the amount of the agreement is different from the evaluated value, and at the United Register of the Taxpayers regarding amounts of income, your wife in July 2022 indicated that she received from alienation of property the amount of 108,000 hryvnia, and it corresponds to the evaluated value. How can you describe this discrepancy? I think that she explained it to me some time ago. It's something like that the tax inspection took this price, this amount from the evaluation report, but de facto the price that is reflected is the one which was received by my wife. So regarding tax accounting things, I cannot provide additional explanation. It was indicated as an income from the selling of alienated property. Where the tax inspection takes this data from the notary or from the tax agent. Maybe the notary indicated this amount indicated in the evaluation report rather than the one indicated in the agreement, because I don't know why the notary should have indicated the amount mentioned specifically in the agreement. Okay, then regarding the loan, which was so many questions you received from Mr. Robert. So regarding your notification of significant changes in property status as of 2nd October 2021, you returned. So he gave me a loan, and on 2nd October 2021, you returned it. But in Declaration 21, at the financial obligations section, you indicate that the financial obligations that you have 400,000 hryvnia. Yeah, you provided explanations. Yes, I provided explanations to BZI, and I mentioned in a nutshell that another part of a loan was given in installments through relevant written notifications or written statements, and those written statements are provided as a copy to the PCIe, and those sums which were provided in such parts and installments were below the threshold for declaration, and that's why I did declare it. And a part of information that provided it to the PCIe later, I also looked at my materials of the judicial dossier. I saw those documents that were provided by the NSCP to the request of the Commission, and among those documents, there are also my notification in the electronic declaration system, where I also mentioned such loans. I realized there could be some questions regarding this part, so when submitting a declaration, I reached out to them saying that there were also other borrowed amounts, and I mentioned the relevant figures. I even forgot that I contacted them regarding this issue, but when I looked at my dossier, I recalled that actually this information I mentioned to the NACP when I submitted declaration. So as of the moment of submission of declaration, what was the amount of debt? Again, sorry, as of 2021, when I returned it back, 780,000, 755 or 50,000. So yeah, something like this, 750,500. Yes, that's what I returned. And at the same day, you received a gift from your father at the amount twice as much that I returned. Yes. Do I understand correctly that this amount of 780,000, that's what you physically returned back? This money were physically at my hands, but the notary didn't require it to have physically transferred from hands to hands. Didn't happen, the transfer. So my father noticed to me that this money is yours right now, the money which I should have returned to him. And plus he added 700-ish thousand, the left, so the residual part according to this gift date. So we didn't need to physically transfer from hands to hands this amount of money. We're a family, in order for doing what? It was just, so we took this money. If a notary says that we need to carry out this ritual of transferring money from hands to hands, but there was no such demand.
Ще від Transparency
And
International до нас
another question from the Transparency International. They have received
щодо притягнення вас до дисциплінарної відповідальності.
information regarding bringing you to disciplinary liability. What can you inform about?
Сьогоднішній день, згідно з законом, вважається таким, що погашена це дисциплінарна.
So as of today, this disciplinary sanction has been covered, and I'm making steps to appeal, and I have been taking steps in order to speed up the process of appealing, and I turn to the High Disciplinary Commission and the High Council of Justice for them to speed up the consideration of the appeal, and to the best of their ability they did it. And I can now switch to High Chamber of the Supreme Court. As of today, only one session took place, and last September, I submitted my appeal. This year, January 15th, the first session took place, where the position of the parties were heard, and because the representative of the High Council of Justice couldn't answer the questions indicated in my appeal, she received an additional term to provide written answers to the address of the Supreme Court, and therefore the case is delayed until April 2nd. Why do you think the disciplinary sanction is covered? Because there was a warning, and the term for its execution is 6 months. It was made in last June. The warning was made last June, and the deadline was in December. Thank you. No questions, colleagues, any questions on your part? Just a couple of questions regarding your practical task, if you remember the details of it. I would like to clarify a couple of aspects. You were rather broad and abstract in the question about qualification and the law on criminal liability. In the beginning, you say that criminal liability is indicated in the appropriate law. And then when it comes to punishment, page 12, under such circumstances, the court issues a fine according to Articles 361 in the corresponding version. Which version are you referring to? So I actually got familiarized myself with my answer to brush up in my memory. So the sections of the judgment, because of the short. So the time that I had for practical task was short, and I didn't have opportunity to refer to the proper texts well, so I referred only to some in the part of predisposition. Then in the part of sanction, I needed to refer to the clause that is applied in determining the type of criminal liability. I didn't mention the date, and I mentioned, so what I referred to was the version of the article effective by the time of committing a crime.
в новій редакції такого покарання неможливо в
And
принципі було призначити, то
in
цього
new
можна хіба що зробити
version
висновок, яку я
of the
редакцію
text.
застосував.
So actually, we couldn't even talk about this topic because it was absent from the new section.
Покарання призначено на строк до 2 років.
Так, можливо, я
So the additional punishment that you are mentioning
просто
is for 2 years.
хотів ще перечитати його,
And
просто
can you explain it by
залишився
the
час.
shortage of time? Yeah, exactly. Probably I just ran out of time.
Тоді, так, Михайло.
Fine, colleagues.
Будь ласка, хотів би більш детально поговорити з вами про
I would like to talk with you about disciplinary sanction and consequences of it. When was the decision taken? June 2025.
Зараз я точніше
And the
що
date?
сказати, у мене десь є це
I will
на
check it
моя
up,
скарга.
look it up.
Там, здається, було 25
I have it in my appeal. June 25th, I guess.
Так, отже, рішення дисциплінарної палати було
So
від
decision of the disciplinary chamber is of June 23, 2025. When do you think you were believed as such?
Якщо я не помиляюсь, законом
Who
визначено,
is
у випадку,
no longer
якщо застосовується стягнення у
accused
вигляді
of
попередження,
disciplinary
то, такі строки
offense?
рахуються 6 місяців з моменту
So the
ухвалення
deadline was 6 months
до дисциплінарної відповідальності.
after the decision is issued.
Документами про участь у конкурсі ви
And
звернулися?
Я звернувся, коли ще
when
діяло
did
дисциплінарне
you
стягнення. Водночас,
submit your documents? So because of limitations around my participation in the competition, when there is a still ongoing disciplinary sanction, I could turn to a different it is possible, though, if I'm running for competition for a different court. So, Part 7 of Article 109 is not applied here. Do you think so?
Тобто, оскільки ви претендуєте на заняття посади
In order to be
судді, ви вважаєте,
appointed to the position of a judge in different court, you should not have disciplinary offenses. Well, actually, you're working in the same institution. Okay, I just wanted to hear from you. I knew that you could ask me this question, but the situation is like this currently. Thank you.
Доброго дня. В продовження
Hi.
питання мого колеги.
To build on what my colleague asked,
Готували мотиваційний лист, зокрема,
so you wrote a motivation letter following the form agreed by the Commission, and Clause 8 required you to provide information about circumstances that could pose concerns about your participation, your eligibility. And did you fail to perceive that a disciplinary sanction could be one? Well, actually, look, just in your motivation letter, the date in the letter is within the deadline for you to cover this. Is beyond the period of your execution of disciplinary sanction, but at the time when you made your letter, there was a proceeding, disciplinary proceeding. Did you fail to realize that you needed to point it out? So I informed the Public Council of International Experts of that once the Public Council approached me with this issue, and I believed, look, it's a different issue. Let us come back to what I'm asking. So I did not really take these circumstances as such that I needed to let the Commission know of. If there are no other questions, then you've got 1 minute to state something you haven't yet mentioned. I would like to thank for your time, and I will not take up any more of it because your work is a complex one and it's worthy of praise. Thank you so much for your participation in the interview. The interview is finished.